Welcome to LexAI, your AI-powered partner in mastering the law. We combine artificial intelligence, legal analysis, and jurisprudential insight to make complex legal doctrines clear, visual, and easy to understand. All right, today we are diving deep into Rule 90 of the Rules of Court. Now, this rule is all about the grand finale of settling an estate, the actual distribution and partition of everything that's left. We're going to walk through it piece by piece. So, just imagine this scenario. The long, often complicated process of settling an estate is done. The debts are paid off, the funeral's taken care of, the taxes have been handled. You're left with the remaining assets. The big question is, now what? How do those assets actually move from the estate and get into the hands of the heirs? Well, that is exactly the question Rule 90 is here to answer.
So here's our game plan for this explainer. First, we'll introduce Rule 90's place in the whole process. Then, we'll get into the nitty-gritty of distributing what's left of the estate. We'll also tackle a really interesting topic, how the law handles gifts given during a person's lifetime. After that, we'll see who pays for the final expenses, and we'll wrap it all up with the core principles you absolutely need to remember.
You can really think of Rule 90 as the final chapter in the book of estate settlement. Its entire reason for being is to lay out a clear, orderly, and legally sound roadmap for the court to formally hand over the property to the people who are entitled to it. It's about finishing the story correctly. Let's jump into Section 1. This part is crucial because it sets the ground rules for when the court can even make that final order of distribution. And trust me, it's not as simple as just saying, okay, let's divide it all up. There are some very strict conditions that have to be met first.
And the key word here, the one you absolutely need to know, is residue. In legal terms, the residue is simply what's left over after every single obligation of the estate has been paid in full. This is the net estate. This is the actual pot of gold at the end of the rainbow for the heirs.
Now, before you can even begin to calculate that residue, the court has a checklist. It makes sure that all these key obligations are paid off first. We're talking about the deceased person's debts, the funeral costs, all the expenses of administering the estate, any allowance for the family, and of course, the government gets its share through inheritance tax. Only when these 5 categories are zeroed out can we start talking about distribution. So here's the deal. Section 1 gives the heirs 2 distinct options, 2 paths forward. Path A is the standard route. You pay absolutely everything first, and then the court distributes what's left. Simple. But what if the heirs are in a hurry? Well, there's Path B. They can ask for an early distribution. But, and this is a big but, they have to post a bond. This bond is basically an insurance policy, a financial guarantee to the court that any outstanding debts will, for sure, get paid. This brings us to a perfect, classic bar exam question that really tests whether you get this rule. So, can a court just take the heirs at their word? What if they all get together and promise, hey, don't worry, we'll pay the debts later? Can the court just go ahead and approve an early distribution without that bond? What do you think? The answer is a clear and absolute no. The rule leaves no wiggle room here. The obligations must either be fully paid or a bond must be filed. There is no third option. As the jurisprudence, like in Fuley versus Court of Appeals, has made clear, any court order that allows an early distribution without a bond is premature and can be struck down. That bond isn't just a suggestion, it is a mandatory safeguard. Okay, so we know how the residue gets distributed, but what about money or property that was given away before the person passed away? This can be a huge source of conflict in families. Luckily, Section 2 gives us the legal machinery to make sure everything is handled fairly. This is where we get into the concept of an advancement. The easiest way to think about it is as a prepaid inheritance. It's a gift, say from a parent to a child, that was given with the understanding that it's an advance on that child's final share of the estate. So how does the court actually account for these advancements? Through a process called collation. Here's how it works. First, they figure out the total gross estate. Step 2, they add the value of that advancement back into the total, almost like it was never given away. This is sometimes called bringing it into hodgepodge. Then, with this new, larger total, they calculate what each heir's legal share should be. And for the final step, they simply deduct the value of the advancement from the share of the heir who already received it. It's a really elegant way to ensure fairness. So let's test this with another scenario. Say a father gives his son 2 million pesos to start a new business. It's a huge gift, but there's no piece of paper that says, hey, this is part of your inheritance. So, how does the law see this? Is it automatically an advancement? And the answer is a classic lawyer's answer, it depends. It could be an advancement, but everything hinges on one word, intent. The burden of proof falls on whoever is arguing it was an advancement. They have to show clear evidence that the person who gave the money intended for it to be a prepaid inheritance. If they can't prove that intent, the law just assumes it was a simple gift, a donation, and it's not counted against their share. All right, we've figured out who gets what and how to account for past gifts. We are so close to the finish line. But there are still a couple of final but very important procedural steps: paying for the costs of this whole partition process and making sure the new ownership is officially on the books. That's what sections 3 and 4 are all about. So, who actually pays for things like the surveyor's fees to draw new property lines or the appraisal costs? Section 3 sets up a clear pecking order. The first choice is to use any leftover estate funds that the executor may have set aside for this exact purpose. But if there are no funds, or if using them would be unfair, then the heirs themselves have to chip in, each paying a portion that's proportional to the share they're getting. And now for a step that is absolutely 100% critical, especially if any real estate is involved. Section 4 says a certified copy of that final court order for partition must be recorded in the registry of deeds in the province where the property sits. This isn't just some boring paperwork, it is essential. And why is it so critical? Because an unrecorded partition is basically invisible to the rest of the world. It's not binding on third parties. Think about it. If an heir doesn't record their new title, someone else, like an innocent buyer, could come along and acquire rights to that property, and they wouldn't be bound by the unrecorded partition. Recording puts everyone on notice. It screams, "This property is mine," and protects the heir's ownership. We have covered a lot of ground, from debts to bonds to advancements to recording, so now let's just zoom out and pull everything together into the core principles of Rule 90. This will help make sure these key ideas really stick with you. Let's just do a quick recap of the entire flow. Step 1, from Section 1, no distribution until the debts are paid or a bond is posted. Period. Step 2, from Section 2, the court settles any arguments about lifetime gifts using the process of collation. Step 3, from Section 3, the costs of the partition are paid either by the estate or by the heirs. And the final, crucial Step 4, from Section 4, if you get real estate, you must record the order to protect your rights against everyone else. And hey, if you want a super simple way to remember all this for an exam, here's a handy mnemonic. DAPR. D is for distribution. A is for advancement. P is for partition expenses. And R is for recording. DAPR. That's the 4-step framework of Rule 90 right there. So when you boil it all down, what's the big takeaway from all of this? In summary, Rule 90 teaches us that the final distribution of an estate must be as orderly and just as its settlement. It's not a free-for-all. It's a structured, fair, and legally sound process to ensure that once all the dust is settled, what's left is transferred to its rightful owners in a way that is final, fair, and most importantly, legally protected.